Welcome to our Successor Trustee training class. This is the first of our Nuts and Bolts series of foundational teachings in the estate planning world. We do these classes in order to help you, not only as a client but also as a family, to understand the process, the concepts, and all the practical aspects of various phases of the estate planning world. And so this is Successor Trustee training. This is proactive. We want to learn now as opposed to waiting until someone has passed away. That's when we typically learn what to do in the estate planning world if we're a successor trustee. But we want to learn in advance, and so that's what this is all about. My name is Doug Anderson. I am the founder and owner of Legacy Estate Planning here in Woodbridge, Virginia. I've been practicing law for, since 1982. I'll let you do the math based on when you're watching this video. But it's been quite a while. And for the last 10 years, I've been a Virginia practicing attorney, doing nothing but estate planning. So rather than just dabble in it from time to time, but really focusing maybe in criminal law or real estate or business transactions, this is all we do. This is our specialty, and we've been doing it for 10 years. So with that in mind, I want to remind you of why we are here and a little bit about my story of what got me started. My first lesson in estate planning actually came on a sunny day in California in a trailer park. I saw a man of about 60, 65 years of age who was obviously grieving. And he was coming to the trailer park where his mom, who just passed away, was living, and he was going to wrap up her estate, her things that were in the trailer. What I noticed that day was the neighbors in the trailer park, one by one, began to come up to him and convey their condolences, but in doing so they would always give two messages. One was how well they knew his mom, and then two, as a result of that strong, close personal relationship, how much their mom had wanted them to have her TV, her couch, her recliner. Whatever it was of value in that trailer, something they wanted was what his mom had wanted them to have. And so they were approaching, obviously, a grieving man who's vulnerable, who was in no condition to be pushing away and standing against this type of assault, really, is what it was. And so by the end of the day, as these neighbors one by one came up and did this, there was really nothing of value left in that trailer. And keep in mind, this was the only son of the mom who passed away. Clearly, she wanted her son to receive these items, not the strangers. Yes, they said they knew her well, but they didn't. The only thing true about what they were doing was not how well they knew his deceased mom, but how greedy they were about being able to get something for nothing. And so that was my first lesson in estate planning, and that stuck with me because that grieving man was my father-in-law, and it bothered me to see him taken advantage of like that in his vulnerable condition. So from that point on, I kind of vowed that as I was getting into law, at some point I would get into estate planning, and I wanted to do so as a means of warning my clients and their families about what happens in the estate planning world in order to kind of protect them. So with that as a background, let me kind of give you an overview of where we're going today. These are the goals of what we're going to cover. We first want to give you a nice overview of the settlement process so you understand the big picture. We want to give you an idea of the types of issues that you're going to deal with. And those issues can be rather broad, some can be rather unique, but just covering the main ones that you're likely to face. I want to also introduce you to the firm's own settlement process. Yes, we have a system. It's designed to work, and it's been used quite a while, so we know it does work. And so if we can just let you know that we have a system, we can relax, let's just rely on that system, it makes everybody feel a little bit better and more confident. And as a result of all of that, we hope that you leave this teaching with a greater peace of mind. And that's the desire, that's the goal. What we want to do is break this into two phases. The first phase is a part of settlement that you may not even consider before. When we think about settlement, we think about death settlement, when someone dies. But there is also an aspect that can come up quite a bit, especially with Alzheimer's, dementia, those kind of things, where we need to deal with mental disability planning. So you might have a situation where you're called to be a successor trustee, where mom or dad, let's say, are still alive, but they're mentally incapacitated. You need to handle their finances. You need to do certain aspects to help carry on their lives, but they still are alive. And that's a whole issue that is often overlooked in the estate planning world. So what I want to talk about here is the fact that there could be some very unique aspects on the mental disability side of the house. Because one of the things we deal with primarily in mental disability is not the situation where somebody was maybe in a car accident and they had brain damage and everybody knows it right away. The harder situation actually is if it's in the dementia or Alzheimer's situations. Those kind of cases arise gradually, and figuring out whether someone has finally reached the point where they're incapacitated or not, that is a situation where it's rather subjective, right? So it's very difficult. And because it's subjective, we have some special, unique issues that we need to address in advance. Again, I always find it better to learn these things proactively rather than waiting until something has happened. So keep in mind the determination of whether mom or dad or whoever the loved one is incapacitated is subjective. Also, there are no bright lines. People don't suddenly have a sign on their forehead that says, I'm mentally incapacitated now. There's nothing like that. You're going to have to kind of do your best to figure out what the signs are. So these cases are inherently more difficult. The other problem is the decision, once made, can have devastating consequences. You will kind of, if you put yourself in that position of someone trying to determine whether you're incapacitated or not mentally, once you're found incapacitated, typically you don't get better and come back from that. You don't recover from that. It just gets progressively worse with Alzheimer's or dementia. And so once someone is found incapacitated, you can't put the toothpaste back in the tube, and now we're stuck. And what the consequence for the person who's found incapacitated is that you just lost control. You lost your independence. You can no longer go to the banker or the lawyer or your financial advisor or whoever it is and make decisions. You've got to act through an agent, who in this case would be your successor trustee. So this is a very important decision that needs to be made carefully. So there's some things that we can do as we see the problems begin to arise. We don't have to wait until it's too late. We want to be, again, proactive. So there's a couple things we want to do. First, we want to finish our homework if we're the client, if we're the one who's starting to lose that capacity. Now, what do I mean by that? I mean 2 pieces of homework that we ask all our clients to complete after their trust is signed and completed. And those 2 items are both in the red binder. So the red binder, when we talk about the red binder, it's a rather big 3-ring binder. This is where all the estate planning documents are found. Not just the trust, but the power of attorney, the medical directive, living will, all that is in one place. So this is what you're going to be looking for if you are a successor trustee. So you'll want to know where that is in advance. But the 2 pieces of homework are going to both be towards the back. One is going to be under healthcare powers. And what that looks like, and it's going to be hard to see on the camera, but I'm just going to give you an idea. It's a white sheet of paper that is fill in the blank. It's got some things to fill out, things like that. That's one piece of homework, the healthcare agent instructions. It's behind the tab, healthcare powers. So make sure that homework has been done by you, the client. That's something we can do proactively. Right behind that tab is a tab called Memorial Instructions. Same type of thing, it's a fill-in-the-blank type of arrangement, it's homework, but this again gives guidance and direction to your successor trustee as to how you want the funeral to go, the memorial service, who you want to preside, what songs, what scriptures, even the atmosphere. We had a colleague who asked everybody not to wear black because she wanted it to be a celebration. So it's whatever you want to do, but these are your intentions that your successor trustee needs to know about in advance. So if we find that we're starting to lose it mentally, now's the time, if we have not done that homework before, get that homework done. Other things we can do while we're starting to notice that there might be a mental issue. We need to start documenting the client's intent for various scenarios. We have helped with that situation. Again, in the red notebook, towards the back, we have had our clients fill out memorandums of intent, basically to cover big picture items like, I'd like to always save taxes, so do what you can to save taxes, those kind of things. So we want to make sure we've got those filled out, and we've got any other intentions of that client filled out in advance in writing. That gives the successor trustee the authority and the direction and the map for how to act, how to carry out the wishes of the person once they are mentally incapacitated. What's interesting is, if we do this in advance, that type of proactive strategy really pays dividends. Because after someone becomes mentally disabled, we can't make changes. But we can make changes if it's consistent with a prior direction that they gave us. The other thing we can do is start working with the client and the family about expanding that release of information that we can do. Remember, as a client, you have an attorney-client privilege. We cannot release or talk to anyone about your plan without your permission. Well, at this stage, we're probably going to need to start talking to some people, maybe your successor trustee, but they haven't been appointed yet. Once they're appointed, I have authority to talk to them. But prior to their appointment, I don't have authority without your permission, without your consent. That's that attorney-client privilege. So now's the time to maybe gather the family and have you tell me, who can I talk to and how far can I talk to them? What are my limits? What are my constraints? So we can start addressing those issues now. The other thing is, we may want to start considering, depending on your situation, do you want to already resign your trusteeship? Remember, as the maker of the trust, you're already the initial trustee. But if you see signs of dementia or Alzheimer's coming, and you see the writing on the wall, maybe you want to go ahead and resign early. That's one thought that we can do. But that's a discussion, it's communication. And you'll find in this arena, good communication resolves a lot of issues. So one of the other things we could do is have a pre-signed resignation where you sign it, but you don't want it to go effective, become effective immediately. So we can hold that for you, and we can hold it until you either tell us, okay, I'm ready, or maybe the family says, yeah, it's time, if it's getting there. So we can make the date, the effective date, much later than when you actually give us the resignation letter. But the work has already been done. The transfer process is already being made. So the key is to have these discussions, have these communications made while we're still competent, and we can still voice our opinions and concerns to our family. Now, what we've done in every trust with our clients is some, what I think are cutting-edge aspects of providing extra protection to prevent our clients from being found prematurely mentally incapacitated. So what we have done is we've allowed our clients to actually determine what it's going to take to find them mentally incapacitated. So if you stop and think about it, if you don't have an estate plan at all, you will be found mentally incapacitated when one doctor says you're mentally incapacitated because you don't have anything else in writing. The best plans out there tend to add another layer of protection by saying a second concurring medical opinion. That's fine, But even for that, we don't think that goes far enough in providing protection. So we like to go even a step further than those best plans out there. And that is recognizing that the issue of Alzheimer's and dementia is so gradual and so subjective that it is more than just a medical decision as to when somebody is mentally incapacitated. It's also a personal decision that the doctor won't have any expertise about. So the doctors can provide the medical aspect, but we need a family member to provide the personal aspect. Because again, what if I see the doctor at 4 in the afternoon, and that's my bad time of day, and I see some bad things? I could be found prematurely incapacitated. And the typical scenario with dementia and Alzheimer's is maybe even after I've been diagnosed. The morning, I'm just fine. I can make great decisions. I can do the checkbook. I can work with my financial advisor, my lawyer, my doctor, whoever. Early afternoon, I'm starting to lose it. Late afternoon and evening, I've lost it. I need to be watched over. Take the checkbook away from me. Don't let me near making any big decisions, because who knows what I'll decide, right? But I've got about a half a day or more where I'm very lucid, and I can still have that independence and control. If we have a family member on that, we can take advantage of those periods of lucidity, and the family member can say, no, Dad is still doing good, or my husband or my wife is still doing fine. So by having a spouse or a child, for instance, on the panel that is required to agree with the doctors before we're incapacitated, that could give us a lot more years of independence and control. The idea being, I don't want to be found incapacitated in years 1 or 2. I want to be found incapacitated in maybe years 9, 10, or 11. And I have that extra protection because I've got a family member who knows me and who can make that other assessment. So that's what we want to do. And notice how easy this is to work. Obviously, a spouse is right there living with the situation. They can see the next morning the husband or the wife is just fine. But what if the spouse is predeceased or has their own mental issues? Then we could have a backup of the children, for instance. The children could be living in California. They could be living anywhere. And one phone call to mom or dad, and I guarantee you in a minute or two, you're going to know as a son or daughter that, oh, that's just dad being dad, or, oh, dad's different. Something is wrong. You're going to know that right away because you know that person. And that's where the protection comes in, and that's how that works. So we have in Article 4 of the Trust, Section 2, this disability panel, and that's what you're going to want to look at. And of course, you're going to want to talk to us, and we'll show you how to work that. But just so you know. Now, interesting, when someone passes away, we've got a system to prove that person passed away to the financial institutions without having to cart the dead body carcass into the financial bank institution. We use a death certificate, right? So you just show the financial advisor the death certificate. We've never had anything like that for disability. We've always kind of overlooked that area. But now we're kind of getting on board here, and we're realizing the institutions need something. So we have developed a disability certificate. We show that to the banks, show that we're the successor trustee, and that's the practical side of being able to start working on behalf of that person who has lost that capacity once it happens. And then we decide what assets to work with. We don't necessarily have to go full-blown pulling our names off of everything. If I'm the one who's incapacitated, it's probably okay to leave my name on the deed of the house because there's not much damage I can do there. But the cash accounts, the investment accounts, you probably want to take my name off of those accounts because I could clean out the bank not even knowing what I'm doing. I could be watching QVC channel all day long and buying everything that they offer, and suddenly the bank account is gone and everybody's shocked. So we can decide as a family what accounts that person needs to be taken off of. Again, it's a planning, it's a communication situation. We don't have to panic. Now, what about in terms of updating the portfolio? And when I say portfolio, I mean the red binder. I mean everything. Not just the trust, but the powers of attorney, everything. But specifically, for our purposes today, we're talking about the trust. How do we update that trust over the years if they're on the maintenance plan and we're trying to keep this thing current? Well, the general rule is that you can't make changes to a trust after someone has become mentally incapacitated. Same thing with death. You can't make changes in that sense. However, if we have already provided in advance for making those changes and we've put it into the trust, where under these circumstances we can do these changes, like using those memos of intent, then we can make changes. So we use the pre-signed memos of intent that are in the binder. And it allows for general updates as well. So those are already provided for in that red binder. And it allows us to keep the plan current. We can't make changes, personal changes that they might want, because they're not going to be able to give us those. But law changes, technique changes, things like that, we can keep it current. In addition to the pre-signed memo of intent, we also have in Article 16 of the trust a reference to a trust protector. The trust protector is an independent person, typically the lawyer, who is appointed by the trustees or all the beneficiaries, who can make changes to the trust, but those changes have to be consistent with what the trust maker would have wanted had they been able to make those decisions. Again, that goes back to the importance of having a memorandum of intent, because those memorandums of intent give us the trust maker's intent to make the changes. So we can do that, and based on that, we can even make specific changes. So overall, what we've done with some proactive training and counseling and planning is we've set up about the best protection you can have for mental disability planning. All the determinations are made privately without court oversight. Disability definitions are there in the trust as a contractual thing, so they're legally enforceable. You don't need the court to intervene. It allows for greater protection than just the opinion of two doctors who don't know us. That panel allows the family to be involved in a very positive way to help protect us. And then we have written instructions and guidance along the way. So proactive steps we can do while we're alive. First, we want to make sure we can fully fund our trust and that the trust is fully funded. Here's a good point to just pause just for a moment to remind ourselves the concept of a trust. It's a two-step process. So when we create a trust, the documents, or this red binder containing the documents, is like a container. It's like if you picture a treasure box. A treasure box is a container, right? But you also know that if you were to be fortunate enough to be walking along the beach someday and come across a treasure box, you're going to get pretty excited, right? But there's something you're going to want to do right away, right? You're going to want to open this thing up, because you know that if this box is empty, it's nice, but it's not valuable. Well, if you also open it up and it's full of bright, shiny objects, now you're going to get pretty excited. Well, that's the value of a trust. We have to not only create the trust documents, the portfolio, that's just a container, but then we have to retitle our assets into the name of the trust, which puts them in the treasure box, and that's where the protections come. So unless things are all in the trust, we don't have the full protections. And typically, over time, clients will buy more pieces of property, open up new accounts. So we need to stay in touch and make sure those things are all in the trust. So one of the things we can do if we know there's some issues coming is check and make sure everything is properly in the trust the way it's supposed to be. We want to complete a location list with passwords, if appropriate, of various items of property that we have around the house, especially items of value that we want to make sure is found. We can do a lot of things. If you are one of those who likes to hide cash in the house, under the mattresses or in the books, identify where that is on behalf of your family, because that's one of the big issues we face, is a family coming in after you passed away and they can't find it. Now in some cases, and I know of one person in particular who has told me they have several $1,000s of cash stashed at various places in their house. I urge that person, Either get that out and get it in a bank or something, or at least tell your family where you're hiding it. Well, they can't even remember where they put it. So now we're really in trouble. We can't get around that problem. But to the extent you remember where everything is, let's get all that stuff located and know where the valuables are. And then, of course, keep the law firm and your successor trustee and the beneficiaries informed as to these things and the information, and keep that information current. And then finally have that complete set of memorial instructions ready that we talked about before, that homework. So, some proactive lifetime steps we can take. One is to consolidate investments. If we know we're starting to get into that mental disability situation, or maybe as a precursor to death, start consolidating investments. You know, it's a lot easier to settle an estate where we're going to 1 or 2 banks as opposed to 10 or 12 or 15 banks. I've got one client who was the byproduct of the Depression. So I get it. They're nervous. They don't trust banks. They saw in their lifetime where banks closed and money was lost. So to protect them, they have accounts in 20, 25 different institutions. Well, if they were to pass away in that situation, that's going to take a while to get all those accounts closed. Where we can still have diversification of investments, IRAs, all under one umbrella or 2 umbrellas of just a couple financial institutions, it makes it a lot easier. So consolidate accounts, that's one thing we can do in advance. Secondly, attack the clutter. Clutter is a major problem. Now, we can leave it to our spouse if we're married and let them deal with it. Or if we're single, or the second of us to die on a marriage relationship, we need to attack that clutter and get things taken care of on behalf of that successor trustee who's going to have to deal with this. So the more you can do there, the better off we are. Complete your special stuff list. You know, we all have special things, maybe some mementos, some things of significant value that are just in the family that we want to keep and treasure. Get a list of those things and who you want it to go to so that people aren't fighting over them. That will help a lot. And then deal with the case of the overly competent spouse. This is so typical of a married couple where one of the spouses is particularly adept at the finances and organization and handles all the bill paying. But typically, too, the other spouse kind of lets them and ignores that situation. And so we need to make sure that we inform the other spouse that we have that covered and where things are, how we're doing it, so that if we pass away, typically the person who's the competent spouse passes away first, you know, Murphy's Law, that the second spouse knows where things are and can have that smooth transition. So we want to do that. So now is the time to get organized on the mental disability side. Know where that binder is kept. Know where the list of assets are. Asset information is located. Establish points of contact for life insurance and all that sort of thing. And then know the contact information for the law firm. That will be on the inside part of the binder, of the red binder. So make sure we're in the loop as we go forward. Okay? All right, that's what the first part of this class is about on mental disability planning. And now let's start talking about planning upon death, what we typically think about death planning. So let's now start talking about the death settlement aspect of successor trustee training. This is an area that we typically think about with successor trustee training. We tend to forget the first part of what this class was all about, the mental disability side. But this will come up sooner or later. We haven't invented a way to last forever, so sooner or later, as much as we love them, we're going to lose our loved ones. And so we need to be ready, we need to be proactive. So what I wanted to start with is a schematic diagram, kind of showing you the process of what happens at settlement with a trust. We're going to start with a married couple because it's a little bit different. The concepts are similar, but there's just a little differences. So we both start with a revocable living trust while we're alive and well. We can get into those trusts for any reason. We don't need permission. We're the trustee, we're the beneficiary. There are no restrictions at all. But when someone passes away, our revocable living trust becomes irrevocable. And if we do things in a certain way and follow the rules of the trust, then we can do some very good things to help achieve the purposes that the trust makers had in the first place. So this diagram shows the deceased person, their trust is now gone in that official way, and we create what's called a temporary holding pen, so to speak, called an administrative trust. In Article 6 of the red binder in the trust, it talks about setting up an administrative trust. This is, as I say, temporary. We're only using that to pay the bills, to pay the funeral home, out of the deceased person's assets. No successor trustee has to pay out of their own pocket. Keep that in mind. Although, with the one exception of sometimes the funeral homes don't want to wait until we've set up these administrative trust accounts. So there may be a situation where a trustee has to pay the funeral bill to begin with and then gets a reimbursement from the estate later. But bottom line is you're not going to be paying anything out of your own pocket. We create this administrative trust even on a married couple. So here's a myth and something we need to deal with right off the top, is the idea that this is all about distribution and that's all I need to worry about. So if I'm the surviving spouse and my husband or wife wanted me to get it all when they passed away, what is there to do on a settlement? There's nothing. And so we just take all their assets, put it in our name or our trust name, and go about our merry way, right? If we do that, we have greatly damaged the ability to carry out all the plans and purposes and goals that our deceased spouse may have had. So this kind of requires us to take a step back as to the fact that we can do a lot of asset protection for our loved ones after we're gone. I'm going to cover this just a little bit. This is something we cover with our clients. So I'm just going to give you an overview. So remember I said when we die, the revocable trust, which has no protections for assets, asset protection, becomes irrevocable. And now any assets in that irrevocable trust is protected against the judgment creditors. After we set up the administrative trust, which is temporary, and pay all the bills, then we create one or two sub-trusts. It's up to us, depending on what the situation is. A family trust and a marital trust. Typically, we fill the family trust up first. That is filled up to whatever the amount is at the time for the estate tax exemption amount. The idea being if we have assets under the estate tax exemption amount, we pay no estate tax. Which, by the way, you never want to have to pay because the pay scale is so high. The rates are 40 to 55%, depending on the year and what the law is at the time. So you don't want to ever pay an estate tax. So this is one way to minimize or avoid that. And then if there's any excess to that exemption amount, we put that into the marital trust. Now there's some other reasons to have a marital trust that we're not going to go into for now, but keep in mind the idea is there may be one or two sub-trusts, a family and a marital, that are created. These sub-trusts are both irrevocable. That means they're protected completely from judgment creditors that might be out there. If we fail to set these up, we lose asset protection for our loved ones. So let me give you a sad story, and this is a real story of what happened, based on the fact that most people think there's nothing to do when the first of a couple passes away. When I did the planning with this couple, the husband was already battling cancer, and he was losing that battle fast. So it was important for him to know that we were setting up an estate plan for his wife that would give her a lot of protection, asset protection. So we set up these trusts, these irrevocable sub-trusts in his plan. But it required, when he passed away, that we set them up. They don't just magically appear. It's not like Mr. Potato Head suddenly sprouts arms, legs, and a brain. You know, this thing does not do things on its own. It's an inanimate object. Somebody has to do the work. So even though the plan said to set these up, somebody had to set them up. And so that is typically our job. And so when she was grieving, when she was upset, she didn't want to talk to us. And so, you can't force someone to talk to you. And so she went for quite a long period. And during that period, she never set these things up. She never set up the administrative trust. She just transferred everything into her trust. And her trust was revocable, which meant everything that went into her trust was revocable too, with no asset protection. And all that careful planning that her husband wanted her to have was lost. Now let me give you an example of what we're talking about here when we're talking about asset protection. Remember, irrevocable trust protection, if we keep things in trust. So let's say I have an estate plan. I want everything to go to my wife when I pass away. And then when she dies, to our kids, right? So I'm gone. My wife now is running to a meeting. It's raining, the streets are wet, it's a little slippery out there. And because she's late for the meeting, she's driving too fast. Because she's driving too fast, things can happen, brake conditions, all that sort of thing. She slams into the car, killing a whole family of people. Now that would be catastrophic, and around Northern Virginia, it happens all the time. Not just a fender bender, but sometimes deaths occur in these car accidents. Well, my wife would be sued, would she not? Because she was driving too fast. She's going to lose that lawsuit, again, because she was driving too fast. And that judgment for losing that lawsuit is going to be catastrophic. It's not going to be for $100,000, $500,000. It's probably going to be for $1 million, $2, $20, $30, who knows what the circumstances would be. But there are judgments of $150 million per person or more, depending on the circumstances. Well, I didn't have $150 million to give to my wife in the first place. So if there's a judgment creditor out there that can grab whatever money my wife has in her name only, then they're going to take everything she has and she's going to be left destitute. What about the inheritance she got from me? Well, if I had a will and the will said everything to my spouse in her name only, the executor is going to cut my wife a check, right? In her name only. So not only will her money be wiped out by the judgment creditor, but the inheritance I intended for her to have as a safety net to help her the rest of her days is also wiped out. She will be left destitute, except for maybe whatever the bankruptcy court lets her keep, which won't be much, and will not be an estate plan that works for me. That is not what I intended. That's not what I hoped for, right? Keep in mind, the auto insurance policy may have limits of $1 million. Maybe an umbrella policy of $2 or $3 million, max of $5 million. So maybe the maximum protection she might have had is $6 million. Against a $150 million judgment, or whatever it could be worse. So she will be left destitute even if she had insurance. So if we had a will-based plan, that's not going to work. What if we had life insurance and we set everything up so it was in joint tenancy with right of survivorship so that we avoid probate, and we have all these beneficiaries designations and she's a beneficiary? What happens then? Well, we avoided probate. That's the good news because everything flowed to her. But everything flowed to her in her name only. So of all those assets from life insurance, annuities, IRAs, anything with a beneficiary designation, how much of that is now in her name only is going to be wiped out by that judgment creditor? All of it. Again, she's left destitute. What if we set up a revocable living trust, but it was like most revocable living trusts, designed in a limited way to just avoid probate? Our trust is going to say, once you get through the settlement process, cut a check to my wife, Mr. or Mrs. Trustee, and give it to her in her name only. So again, that money will be wiped out. The only way to protect it is if we don't give our money to our loved ones outright with a big fat check, we give it to them in trust. A trust that's now irrevocable and now has full protections. So now if we do it that way, our loved ones' money will be wiped out. We can't do anything about that. But they won't be left destitute. They'll have our inheritance to live on the rest of their days as a safety net. Now that's the plan that works. But in order for that plan to work, we've got to set up the irrevocable subtrust. This is critical. So even in a marriage situation where one passes away and it's all going to go to the surviving spouse, there's still work to be done. Important work to carry out the goals and wishes of the trust maker and make sure that asset stays protected if that's what they wanted. So there is work to be done. It can be done. We just need to come alongside you, walk you through it, give you advice, and help you through the process. The nice thing then is, upon the second spouse to die, we can set up trusts for the kids. So instead of, again, giving them a check in their name only that could be wiped out if they hit the car, or they had a bad marriage, or they had incredible medical bills, who knows? We're in a litigious society. It could be anything. Their money might be wiped out, but they won't be left destitute because they'll have their own separate trust money to live on the rest of their days. So that's the idea. That's the way we set it up. And most of our clients like this asset protection concept, but it takes work. We have to do something. This is what it looks like, but we have to take action. We can't just assume all the assets, because once we take it out of the irrevocable trust, it's unprotected money. We've lost the protections for good. You can't put them back in. You can't say, oops, didn't mean to do that. Let me put that back. It's too late. So we need to be very, very careful. Now, what if it's a single situation? Maybe the second of the spouses to die, or maybe just a person who was never married. What happens and what does it look like when they pass away? Well, again, and I keep referring to the red binder, this is where you start. This is a contract. It's a legally enforceable contract, so we always look to the provisions of the trust. And the provisions of the trust say, set up an administrative trust, that temporary holding pen, to pay off all the bills and things like that. So that concept stays the same. And then instead of sending it to a marital and a family trust, because they weren't married, it's going to go directly, if they wanted that asset protection, to irrevocable trusts for the kids, each one having their own little box of protected assets. So that is a typical scenario. Each trust will be a little different. The point being, this is a concept of what it often looks like, but you have to look to the terms and conditions of the trust itself to know exactly what we're doing and when we do it. So that's the diagram, that's the scheme. I'm a visual learner. I like to see that. That helps me. Now, interestingly enough, if you are a successor trustee, there is a phenomenon that occurs, and I don't know what causes it, but when we lose a loved one, suddenly it dawns on us, oh my goodness, I'm the successor trustee, I've got work to do, I've got responsibilities, and we panic. And somehow we think that we've got to do all this settlement of the trust in about 24 to 48 hours. I mean, that's the way we act. It's like a chicken with their head cut off. We panic and we start running around, oh my goodness, what do we need to do? You know? And we feel like we have to do it all right away. Can I assure you from the beginning that it's not a race? You don't need to panic. There's a system in place. We're here for you. Just call us. There are things to do, yes, but we don't have to do it all at once, okay? So we start by reminding you that a lot of things you don't want to do right away. And we'll talk about this more when I get into our process. But in terms of things not to do, don't close the accounts right away. Don't roll over the IRA. If we've got asset protection concerns we're talking about, and there's a judgment creditor hanging out here over the spouse, the surviving spouse, and we roll over the IRA without thinking, we just lost all those assets. So there's a lot of things we need to consider before we take action. So I urge you, let's talk, let's communicate, let's have a plan before we act. You know, we don't want to shoot first and ask questions later. We want to ask questions first and have a reason for everything we do. So pause, no matter what you do. The other thing not to do, don't endorse any checks. Remember, they were alive when those checks were issued. Now they're dead. Different rules apply. So let's pause. Let's don't cash those checks or any documents in the decedent's name. Please don't drive the decedent's car, even if you know who the decedent wanted the car to go to. Again, there's more at stake than just a distribution issue. That's what we tend to think about. Well, you know, Harry wanted little Susie to have his car when he died. Little Susie lives in California. We actually had a situation I'm aware of where a colleague, their client passed away. The car was to go to a relative in California. The client passed away in Indiana. So one of the family members, just to be helpful, decided to drive that car from Indiana to California. Did they notify the auto insurance company? No. You realize that when a person dies, their auto policy coverage dies with them. So they were driving from Indiana to California, quite a distance, without insurance. That was a disaster waiting to happen. Now, fortunately, they got lucky and nothing happened. But that could have been a real disaster. So don't drive the car until after we've had a chance to contact the insurance company, get temporary policies put into place, whatever we need to do, but don't just start driving the car. Don't remove any household furnishings. This is typically a problem when there's more than one child as a beneficiary. The child, various children, siblings, tend to think, okay, well, the parents wanted us to have this. So they just start going in willy-nilly into the house. They all have keys to the parents and start taking what they want, right? Well, before we do that, we need to make sure there's an equitable distribution because the parents almost always wanted the kids to take it evenly. They don't want to fight. And if we just start grabbing what we want, ignoring what our siblings might want, without even valuing the property, we've got a disaster on our hands. So we need to not remove any household assets until after we've had a chance to figure out what's there, how much it's worth, and who gets what. So just pause, take a deep breath, and this will all get done in due time. Don't pay any bills yet. This is a common concern that a lot of people have, and so almost everybody will be waiting and patient. They won't charge you past due notices or anything. Just notify them with a phone call. Go by their office if it's local and just explain, hey, so-and-so passed away. I'm the trustee. I'm going to get you your money, but it's just going to take a little bit. So please be patient with me. And just communicate with that. We don't have to be paying the bills right away prior to when accounts are set up. Other things not to do. Don't use the decedent's credit cards. A big no-no. Don't contact the life insurance companies yet. Again, is this going to a trust? Where is this going? We need to plan. Don't contact banks or investment institutions, and don't use any power of attorney to do anything as the agent for them on their power of attorney. This is another thing that's not well known, I guess, but powers of attorney die when the person dies. So the person dies, who gave you the power of attorney, and you're showing up at the bank to do some transactions. The bank isn't going to know they died, but you do. So just honor that and don't act with the power of attorney because you lost your legal authority to do so when the person passed away. Now, what about things to do? You know, we said what not to do. There are some things to do. First, notify us. Let us get involved early in the process so we can start guiding you and directing you. It's kind of like walking through a minefield. We can tell you where some of the mines are. We can show you in advance, you know, don't step there, don't step there. This will be what happens. We've been through this process before. So if you can talk to us first, even if you don't want us to do all the work, we'll just work about, you know, whatever you want us to do, we can do. But you need some advice at least along the way. Find and secure the red binder. So when we talk about the red binder, this is what we're talking about. It's pretty easy to find, even in the stack of papers. It's an 1.5-inch binder, 3-ring. You should be able to find this, but make sure as a client that you let your loved ones, your successor trustees, know where you kept the binder. That helps. One thing that gets overlooked is pets. So if there are pets, and it's not a situation where it's the first of 2 spouses to die and the other spouse is still in the house. If it's just a single person in that house and they had a pet, we need to obviously find that pet and make sure that pet is provided for and cared for immediately. That is one of the things that can't wait. They get hungry pretty fast. They can cause mischief if they're left alone. So we need to take care of the pets. Secure the house. This is especially true if there's other siblings. We have seen where the successor trustee is one of 3 children, right? And so they're planning on doing an inventory and finding out what's in the house. But the siblings just go in there willy-nilly to take what they think is theirs without waiting. So we've got to put a stop to that. And sometimes we can't trust our siblings to do that on their own. So sometimes we have to change the locks. We have to do whatever we have to do to make sure people aren't taking things prematurely. And then make a list of questions that you have for the law firm. And believe me, you're going to have a lot of questions. But write them down because, again, you're grieving, number one. So you're not going to be thinking carefully. You're not going to be thinking logistically or in an organized manner. It's going to be kind of all over the place. That's okay. That's just the nature of the beast. But because we know the nature of the beast, let's write down the questions. And that way we don't forget. And when you come to the law office, we can address those questions first. Also, we want to schedule an appointment with the law firm, that settlement counseling session, preferably within 2 weeks of the death. So go focus on the funeral. Check, first thing to do, check for the red binder and go for the memorial instructions towards the back of the binder and see if the decedent left instructions. We had a colleague outside of Cleveland whose client filled out this format really, really well. And I don't know if they failed to inform their family or the family just forgot. But as soon as the person passed away, the funeral arrangements were made, everything was done. And when they get all done, they come back. And that's when they find the red binder and look at the instructions and realize they did everything contrary to what the person wanted who passed away. They felt awful and it was too late. So first step, don't plan the funeral. Go find the binder to see what their plans might have been. Because if they filled that out, they had some ideas. You want to follow through on that. And then you want to follow our process. It's called a process navigator. And we'll walk you through that real quick right now, just so you know. Okay? But before we do, let's just talk about what we call the 9/11 information. This is really the important stuff. So 1, call the law firm. 2, locate that red binder that we've been talking about. 3, relax as best you can. Focus on grieving for a little bit. And remember that there's a dependable process and someone who's going to come alongside you. You're not in this by yourself. We are there for you. We've got this. We've done this many, many times. We know the ins and outs. We know the danger areas. We know where it's safe to walk, where it's not safe to walk. And we'll guide you through that. And we're also trying to develop a helper's handbook, by the way, just as a guide for you. That's not ready yet. Hopefully in the near future we'll have that. But in the meantime, watch this video again, get a refresher, get a reminder of what you can do. Now that's the overall process on death settlement, but let's talk about a couple key specific issues. These issues are common, but they have unique struggles or challenges that are required. So one of those issues is a house. The person has a house. Again, now this is primarily where it's the second of a couple to die or a single person to die, okay? So with the house, you need to decide with the family. The successor trustee has the authority to take action, but they want to take action in consideration of what the family wants, the beneficiaries, right? So again, you look to the terms of the trust. Does it say anything about the house, or is it just part of all the assets that gets divided evenly? And you're going to need to make a decision whether you're going to sell that house and divide the proceeds, or whether you're going to keep the house and rent it out as an income stream and divide the rental stream. Either way, it depends on what you want to do and what the trust says you can do. So the trustee in those situations has wide discretion in determining whether to repair something, whether to sell something, we're talking tangible personal property, or to just throw it away. So again, it's better to have, before you throw anything away, the whole family there of people who are the beneficiaries entitled to get that under the trust, to make sure before we throw it away that nobody else wants something, okay? There's work to be done if we're preparing the house for sale. There's work to be done if we're preparing the house for rental. And so, again, different issues, but we need to be concerned about that. So just be aware of that. Here's the site that you do not want to see if you are a successor trustee. This happens, believe it or not. It can be even worse than this. We've seen some bad situations before. There are some people out there, even our loved ones, who tend to hoard, and so hopefully it will never be this bad. Here's the problem with this. Amongst all that junk are maybe some gems of value, some items that need to be considered and maybe even appraised and sold, and the proceeds divided, right? You're the successor trustee. That means you're a fiduciary. That means you're a trusted agent. That means you are the one with authority to determine what happens with this. And if you've got beneficiaries waiting for their cut or their share of the estate, they're going to be watching over your shoulders. So what you can't do is just look at this and do what is naturally comes to mind, and that is, let's just get a dumpster and haul all this stuff away. You do that, and I guarantee you, you'll be overlooking and throwing away some items of value that are tucked away in all this junk. So again, you're going to have to figure out how to do this. You can hire somebody, or you can do it yourself, or a combination of the above. But you're going to have to go through this and find the items of value that need to be preserved for the beneficiaries to keep you from being held liable, and what can just be tossed or given to charity. Okay? But that's going to be a special challenge. But it can get worse. What if it's actually a biohazard? I mean, this stuff has been sitting there for so long. Now we got rodents, we got wild animals, we got dead animals, you name it. We got hazardous material over the course of things. We need a hazmat suit to get in there. You know, this can be a problem. We had a situation where we didn't realize it was that bad, but all of us who went in there and were working all day long came down with respiratory issues the very next day, and we realized, before we do any more work, we've got to have this thing fumigated and taken care of. So there are some special issues that happen there. So be aware that this could present health issues. You may need to take some remediation steps, pest control, other items of protecting you and your safety before you go in there. You may need to rent a dumpster. You may want to hire a team to do this for you. I recommend that. No amount of money is worth having to go through some of this stuff. If they're organized, if they've been clearing the clutter, okay, maybe you take care of it. But if it's a hoarding situation, really junked up, you'll want to just probably have someone else take care of that for you. Remember, any expenses you pay or hire, use to get the job done of settling the estate is money that comes out of the estate. It doesn't come out of your pocket. So just keep that in mind. And then beware of the money that's hidden between the mattresses, between the book pages in books. The money can be, cash is hidden all over the place. I happen to know, again, another individual who has told me that there are several $1,000s worth of cash that they have hidden in various places in the house. So, of course, what did I do? I said, you got to tell me where it is now. Let's solve this problem now. Well, the situation was, they've done this for so long, they don't even remember where the cash is hidden. So now we're stuck. So sooner or later, this is going to blow up in somebody's face. We weren't able to avoid that. But if that person still remembers where they put it, let's get that taken care of now. Let's communicate with the successor trustee, and let's get that stuff out of there. Put it in a safe place, whatever. But this is an issue. So you can't, again, go into the hoarding situation and just throw stuff out. There may be cash all through there. Of course, you know, who cares if it's just a few dollars, right? But it could be several $1,000s. And again, it's not your decision to make about that. Remember, you're a fiduciary, overseeing and protecting the assets of the estate. And you've got beneficiaries out here watching you who have a piece of the pie and interest in this. So if you throw something away, you're really throwing away their money too. So you could get in a lot of trouble with the beneficiaries if you just waste the assets. All right, that's covering the specific concerns, a couple of them. Now let's talk about the fact that there is a process, and it's a process designed to work. We've gone through this a few times. Like I said, it can be a minefield out there, and we've been through the minefield. We know where the mines are located. That's very important. So let's again start with a schematic diagram. I'm going to keep coming back to this because as we go through the process. Again, know that we have a process. It's designed to work. So we start with being notified. Someone's passed away. Okay, great. Find that memorial instructions and use those memorial instructions to start planning the funeral. Focus on grieving. Focus on the family for the first couple weeks. Whatever you need. We don't need to start doing things right away. Pause. We will send you a common concerns memo, which has a list of a lot of the things we talked about, of things not to do right away, and things to do right away. Find those pets. Even, if you're a plant lover, find the plants and make sure they're watered. So first thing we tell you is stop, get the common concerns memo. Then what we're going to do a few weeks later is we're going to go into the settlement counseling session. This is really the initial meeting. This is where you bring all your questions, and we take care of all that. So we review the common concerns memo, make sure you understand that. We review the overall process so you know what to expect. We review the estate plan. Don't forget the estate plan. Remember, this is a contract. We have to carry out the wishes of that trust document. So we need to figure out what's in that trust. We need to figure out cash flow analysis of the estate. How quickly do we need to set up that administrative trust and get you a checkbook so that you can start writing checks and paying the bills? Those kind of things. We need to start verifying what the assets are, figuring out what the estate consists of, and figuring out what needs to be appraised, what documentation do we need to prove all this, that type of thing. And then we would sign an employment agreement. We would come to an understanding with you as to what work you want us to do, how much that's going to cost, and then we make those arrangements to move forward. And then we decide what work you're going to do, what work we're going to do, and we're going to stay in touch and communicate. We're going to obtain signatures. You need to have some authority to act. Your authority to act is going to be their death certificate and a certificate of trust that shows that you are the successor trustee. Unless a financial institution sees those documents, they're not going to talk to you. You need those two documents to move forward. And we are the ones who can provide you with that certificate of trust. We know how to do that. We'll get that to you. It's sometimes also called an affidavit of trust. Those are two terms for the same document. Then we get releases from you, and we'll apply on your behalf with those releases to get an EIN number. So remember, while the trust was, a person was alive and well, the trust functioned by their Social Security number. Once they passed away, the Social Security number died with them. So now we need to open up a trust with an EIN number, and we can do that for you, and we just need a release from you. Then what we start doing is getting organized. We start building a to-do list. Again, who's going to do what needs to be done, what time frame does it need to be done. It's very, very methodical. We don't miss a beat. So don't feel like, oh my goodness, what if I forget this? What if I forget that? We're on your side. We come next to you. We accomplish this together. You're not on your own. Then what we need to do is schedule the next step in the process, a valuation meeting. So according to our process, we've gone from notification, we've paused, we've had our initial meeting, the settlement counseling session. Now we're at the valuation progress. Now this doesn't have to be a face-to-face, it can be done by the phone. We work with you as to how you want to do this. But here's where we start figuring out what are the values of the assets, getting that inventory and the date of death values all along the way. So this is where we develop an estate inventory report on your behalf. So we're doing a lot of this stuff to help you. And that asset valuation support. Who do we need to get an appraiser? Who does this type of appraisal? Do we even need an appraisal? If we don't, what type of documentation to verify the value is necessary? We'll work with you to get those date of death values and set up that inventory. Back to the process. We've gotten through the valuation teleconference. We're going to have a transition talk. That transition talk is now, okay, we're getting along the ways here. We now need to figure out what the distribution options are. Do any of the beneficiaries need to disclaim? You do not have to receive, as a beneficiary, assets that were designated for you. You may have reasons not to receive them. Maybe you have that judgment creditor hanging over your head. Maybe you've got plenty of money, and extra money is just going to cause you to go into a higher tax bracket or have more tax issues. You just don't need or want the money. You can always disclaim, but can't disclaim until after we've received the money. We have to disclaim before we receive the money. So we need to make those decisions in advance, and this is the time to do it. Back to the process. Now we're going to be checking about funding progress, setting up those sub-trusts, making sure we retitle the assets into the name of the trust. And we're going to set up that final meeting. We're now in the final stages of this process. And so this could be done in a teleconference, the step 4, the funding progress report, or by a meeting face-to-face. The last meeting should always be done face-to-face if we can, because there's going to be some final questions and things like that. But we're there for you. Here's where we can discuss the income tax issues. What tax returns need to be filed. How do we do that? How do we function as a successor trustee moving forward? Keeping records. How do we invest the property? Are we free? What authority do we have to invest the property? And then any other remaining issues and concerns that you might have. There's a lot to be dealt with. There are a lot of issues, but I want to leave you with the impression that 2 things. One, we have a system in place to follow so nothing gets overlooked. And secondly, you're not in this on your own. We come beside you, as long as you want us to, of course, and we help you through this process, the minefield. So this is something that can be done. It's done all the time. It takes time, but it can be done. So, keys to success. We want to do this successfully, right? So, let's start with adhering to the desires of the trust maker. We need to follow the contract, the trust, the document. We need to read this thing. We help you, of course, and we walk you through that. But we need to adhere to the plans and desires and the goals of the one who created the trust in the first place. We need to protect the trust assets. Don't just throw things away willy-nilly. If something is of value, we need to determine what that value is and make sure we've protected that asset for future distribution to the beneficiaries. And then finally, a true key to success is to communicate. Communicate with us, communicate with the other beneficiaries, communicate with the other family members who may not even be beneficiaries, so that they know what's going on as well. The family and the firm, critical to communicate. All right? So that is the end of the workshop. We've covered a lot of material, but I want to leave you again with these final impressions. We've got to follow what is in the red binder. We've got to communicate and get us involved as soon as possible. We come alongside you, and that there is a process to follow that works and it will keep us all out of trouble, keep everybody happy, and hopefully minimize the risks. So I hope in watching this workshop, this helps you feel a little bit better, gives you that peace of mind of knowing that you can do this, and by proactively looking at this, you are already ahead of the game. You are ahead of 99% of the people out there who are named as successor trustees who find out what to do after someone's passed away. You're finding out what to do in advance proactively, and that's going to give you a huge advantage. So be confident you can do this. Thank you very much.